And we have Anna Case Williams with Cedar Grove Law Firm here, and I'll let her get started.
All right, can everybody hear me okay? I should have a mic check. Okay, great. I'm Anna, as Jessica said, and I am absolutely thrilled to be here. We've had the good fortune of talking to other surrounding counties and presenting similar topics throughout the year, and to round it out around the holidays in my home county is just a really exciting thing for me. I hope that my passion for what we're talking about today will become evident as we go through this conversation about succession planning for farms. And just know that I literally live a stone's throw from here, and I kind of thought my mom would come, so secretly glad she didn't. Sorry, Mom. But I do live here in Orange County. My family is in Orange County, and this is such an important topic in the county where we live. So thank you all so much for coming. A little bit about me, not to get too much into this, because y'all aren't here to hear about me, but I am an attorney. We have an office in Hillsboro. My wife and law partner, Jonathan, and I opened this practice in 2020. I'll spare you the COVID details. But needless to say, we started this farm in hopes that we would be able to have this exact conversation on a grander scale. We come from farms. We grew up, he grew up in a farm in Alabama. I grew up on a farm in North Carolina in Randolph County. And we always knew that our pro bono work was going to be farm and succession plan and regenerative agriculture related. And in just kind of leaning into that passion, we're able to start this firm and really focus on our farmers. So we are a very niche within a niche. We service farmers in rural areas, and that's what we do from Hillsboro. We are also, we have offices and presences in Tennessee and Alabama. So we do this in multiple states. It's a very important topic, and increasingly we see in the Southeast it's kind of a pressurized situation because so much of our farmland is being converted to something other than farming. Not the same case as our fellow colleagues that do agricultural law in, for example, the Midwest. When you buy or sell a farm, a lot of times the farm is just purchased for more farm. And the risk of it becoming something other than farming is not as great. So this is such an important conversation. I think y'all know this or you wouldn't be here, so I'll digress there. But we do have a little office here in Hillsboro, so if you ever want to come see us and talk more about this and your specific scenario, there is an open invitation there. I made these slides as cheesy as possible because I am a real, put your tree up after Halloween gal, and just was so excited to speak around the holidays, so y'all get to, see the fruit of my labor here. But in seriousness, I do try to keep this a little light because it is such a heavy, heady topic. Every time a farmer comes into our office to talk about estate planning and to talk about farm succession, business planning, your head spins. There's just a lot of legal stuff that is not really what you don't care about it, right? It's just you need to have it and know a little bit about it in order to do some of the things you want to do. So it is kind of a heady topic. So some of these slides are silly just because I'm trying to keep it a little bit light. Just not taking it so seriously. Talking about death is hard. I don't mean to make light of it. If you come into our office, one of the first things I'm going to say to you is, do I have your permission to have and ask some difficult questions? And the hope is that we are able to kind of move forward and ask some hard questions. And those hard questions are about your family, about your stuff, about the hard things, the things that you may not have had a conversation with your family about yet. So anyway, these slides are a little silly to just hopefully keep it a little light because the agenda is a little heavier. We're going to talk about keeping land in the family, just kind of an overarching macro view of what we're requiring, of what we're asking of our clients when they come in, and really have that as a goal. And then we're going to talk about encouraging your family to create a plan, because I will tell you, and this is the truth, anecdotal or not, the hardest part about this whole process is actually convincing yourself and your family members to walk in the door and take action. That's the hardest part. That is truly the hardest part. It's not wrapping your head around, is it a revocable trust or an irrevocable trust, or when does it become irrevocable? It's none of that. It's always the initial movement forward. So we're going to talk about overcoming some of those hurdles today, and frankly, that's not law. That's just people problems. And so we'll talk a little bit about that, but it is very important in the context of what I do and what our office does, and that is provide legal services. Okay, so we'll talk a little bit about incapacity. That's something that people commonly will overlook in this planning process. Really important. Have some stories I can share related to why that is so important. Business structures for your farms. Some of you already probably have business structures in place for your farms. That's wonderful. We're going to talk a little bit about how those become friends with another kind of succession plan, which is more of a personal succession plan, and how those can be friends together. And then we're going to talk about, I've literally got a list of documents that you need in your succession plan. Take a screenshot when we get there. I'll share the slides later. And then we'll open it up for questions. I know these can be really sensitive topics for everybody, so obviously there's no pressure to share or ask questions, but to the extent that we have a chance to talk about those things today, I'm happy to kind of take some questions from the room and then also stick around after if you have questions. So any questions at the moment before we get started? Okay. Double dice, so it got spoiled earlier. No fun. But we're not your lawyer yet. We're not your firm. So don't rely on anything that I'm going to tell you today as legal advice for your specific situation. I am going to talk more broadly, but I will tell you, in law, some things are kind of cookie cutter-ish, like a real estate closing or certain business contracts can be kind of cookie cutter. This stuff is not cookie cutter. Okay? It's just not. So we're going to talk high level. Everybody's story is going to be different because the people that play in the game are different. The land that we're actually talking about is going to be different. John spends a lot of time out on the farms of some of our clients because it's really important that when we're going to lease a house to mom because she's moving out of the city, that we can kind of see like what all does mom need to access? What all is mom going to want to do when mom moves over to the property with you? Or vice versa. The kid wants to come back, kids want to come back and build on the property. What does that look like? What is the city giving you trouble with? A lot of times we get out on site and look at those things. So just kind of know that everybody's story is going to be very different as we go through this today. And the double dice is just to be silly, right? Because I don't know, disclaimer and double dice just goes together. I'm joking, it's completely ridiculous. Okay, which leads me to the most important slide for today. And this requires audience participation, so hopefully we've had enough Chick-fil-A and coffee that we can help out. But there's going to be a couple times during the presentation where I'm going to say to you, and I'll do like this. And you're going to say, okay, let's practice. Ready? Do you need a trust to pass on your family legacy? Yes. Okay, good. You guys are ready. Okay, let's go. All right, so let's move forward with keeping land in the family. In Orange County, Alamance County, Chatham County, it is so important to understand that you are not experiencing this scenario in the context of average. You are experiencing the need to plan for succeeding farms in a pressure cooker. I mean, big time. Not kind of, sort of. Like, look at the national average, the data that's out there. I'm going to spare you those details because nobody cares about that in the context of today. However, it's there. It's empirical. Look it up. You guys are sitting in a county that is experiencing pressure to keep farms as much or more than any other place in the country. Truly. So, you got to remember that. This is not something that will just, okay, if I set up a plan, it'll happen. It'll just follow. Everything will just flow like I want it to flow. It is a fight. It is a strategic effort. If you have land that you are interested in keeping in your family, it is not enough to just tell your kids, I want you to keep the farm a farm. It is not enough. As a matter of fact, I don't want to get ahead of myself, but this third bullet point here, if you want to guarantee the sale of your farm, then die without a will or a trust in place. And let me just pause and let that sink in for a second. I put a little asterisk because we're lawyers and we're not going to guarantee anything. But in all seriousness, if you want to ensure that the farm that you care so much about keeping in your family does not stay with your family, then die without a will or a trust. Surefire way. And people always say, well, I don't have kids that are like that. I don't have kids that if I tell my kids that that's what I want, they're going to do that. And that may be very true. But here's what we're not thinking about. We're not thinking about the fact that the kids might live in different states, that the kids now have children of their own, that the kids might be part of my generation, which is the sandwich generation, where we're raising young kids and starting to take care of mom and dad, where the pressures of that economically are immense. When you have a developer call and say, I will offer you tenfold what you paid for what your family paid for this property, and there's not going to be capital gains if it's inherited, the sale of that property sometimes becomes inevitable, not because you have a son or a daughter or a niece or a nephew who is money hungry and greedy. It's because life is hard out there. Kids going to college, special needs that other children have that you are going to develop as you age. Those are really hard things, and we see those at the office all the time. Dad is in long-term care. He's cash poor, land rich. What are we going to do? Dad wants the farm to be a farm. But I don't have the money putting my 3 kids through school to keep the farm a farm. We need the cash to take care of him now. He's still living. He hasn't even passed yet. These are real, actually happening, not just once or twice, just every once in a while, blips in our work. This is common. And I cannot stress enough that if you do nothing, just understand that if you really truly want to keep land in the family, it is something you are going to have to do in spite, so I'm kind of going in backwards order here, in spite of fairness to your heirs. And what I mean by that is, we want to treat our kids fairly. The nephew that is like a son to you, who has worked that land, grit, sweat, blood, tears for the last 20 years, who you want to have a piece of that property and you want to treat fairly. You have to understand that if he goes through a bad divorce and 50% of that now is up for grabs for divorcing spouse, farm is gone. It is not like he wanted to do it. It's heartbreak for him too, or her, or the brother and sister who both agree they want to go into this together and keep the farm farming, but one of them goes through a horrible accident, and now we've got medical bills to pay. This is not I think sometimes people assume that it's we want to sell out and just cash it out, but I have actually hardly ever seen that. Matter of fact, when we see somebody who is interested in just cashing out the farm, it's the person who owns the land who comes in and says, look, my kids don't want to farm. I love this land, but I'm ready to just let it go. How do we make sure they get it evenly? And it's really not the fight that I'm talking about. So I don't want to belabor the point, but I do want to just really assure you all that I'm not here to kind of talk scare tactics. I'm here to tell you there is an opportunity to make this happen, actually. So that's where we go from here. I'm going to pause because I know that's a lot. Any questions right out of the gate? Yeah.
Just a high level one. We're talking about family. We're talking about succession in the context of family. Not everybody fits that profile when it comes to succession planning. So I'm wondering if you have the opportunity as you go along to say, now this won't apply to you if you don't have kids, and this will apply to you, that kind of thing. Yeah,
so the question was basically sometimes family dynamics aren't exactly like the traditional family structure. Understanding what you're saying, kind of correct me if I'm wrong. And he was just saying as we go along, if I could kind of mention the situations where it may or may not apply to a family or a kind of a more non-traditional structure, and happy to do that. I'm glad you mentioned that. That's one of the solutions that we have, right? One of the solutions that we're going to talk about is to make it an even playing field, because that is the case. The interesting thing about our world today is that we all kind of walk around and we do what we do, and then the law is 50 to 75 years behind that, truly. And that's just when I go to work every day, I just know I'm signing up for that. The law has not kept up with what we do. For example, the law absolutely loves heterosexual married couples. You get all the benefits. If you die without the will or the trust, chances are we're going to get some semblance of what you might have done, meaning giving most of the stuff to your spouse, if you die without a will. They favor that, right? If you have a partner, a lifetime partner who you just never married, or you have a blended family, the law just like kinks up, can't handle it. So if we die without a will or a trust and we have a blended family, or we have a scenario that may not fit that traditional structure of heterosexual married couple who has 3 kids and all 3 kids are gonna kind of, keep the farm going, then we've got trouble. And that's why we are here today, frankly, is to talk about how we kind of get around that being our only option. Great question. All right, so let's talk about the steps to create your plan. And remember a minute ago I said that the biggest problem that we see in our office is not really it's not a legal conundrum most of the time. Sometimes it's a little tricky because people have very specific values, but it's usually not legally that advanced. It's really more about the people playing the game, like I said. It's more or less really being honest with ourselves about what your values are. And you're like, well, what? That's none of your business, right? Sorta. But at the same time, the only way that we're going to be able to craft a plan and a solution for your farm succession is if we understand what those values are. So what do I mean? What do I even mean by that? You value hard work, let's say. And the nephew that's, like what I used earlier, the niece, let's say, who has blood, sweat, and tears worked that land, went right side by side with you for the last decade. You want to make sure you reward that because that matters to you. Or, that's really nice, and I want to make sure she's compensated a little bit, but she doesn't have the right to live on that land forever because my 3 kids, as much as they haven't been side by side, they're my 3 kids. And come hell or high water, I want this to be theirs. And I want my grandkids, who I'm with every Thanksgiving, every Christmas, to be the ones who inherit this land next. Or, you know what, I got 3 kids, but they have bailed on me long ago. All I've done is cost me a bunch of money, and the guy down the road who has leased and done haylage for the last 25 years is my guy. That's what we want to consider. That's what I mean about values. For example, one of the things I commonly ask when we have a family that comes in who has younger children or children that are maybe tweenish, right, teenagers, I ask them, like, is it valuable? Do you care about providing something for them to get married? Or something for them to graduate college? Or something for them to start their own business? And usually there's like a very visceral reaction, and it's like one or the other. Sometimes like, oh, marriage, who cares? I just hope they never get married. Right? Or it's like, I would love it if they did the trade that they're really interested in and just started their own business. I really think they'd be good at that. It's usually very specific, like how they feel about their kids. So we can create in these plans an acknowledgement of those values that you have. Things that you can't rule from the grave is kind of a legal term that we talk about. You can't rule from the grave, but you can set up some very strategic guidelines, benchmarks, for your people to work through and work with upon your passing. And so that works in the context of farming in that, if keeping the farm a farm is valuable to you, like I said, at some point you are going to have to make a choice for that over fairness to your children. That's going to happen. So naming your values is so important. Ranking your priorities, and that's kind of where I get into the in spite of fairness conversation. Truly, it is difficult to think about having a conversation with your kids to say something to the effect of, I've created a land trust, the farm's going into the land trust, and none of you guys are going to be able to sell that land. That's tough, right? Because you might not have a $1 million 401k that they're going to inherit otherwise. That's hard. At the same time, if you have those conversations, if you talk to your people, it really truly does help them. Not help them like it's a hard, tough love help, but they genuinely want to do what you want to do with your stuff. Like I honestly, they're out there, right? But I mean, I'll be honest, it's a lot fewer than you would think, where people are just kind of in it to take someone's money and run. But genuinely, the arguments that we see between siblings or step-parents and step-kids is really more about both of them caring very deeply about what the person who has passed wanted. They just get to it in different ways. They just disagree on what that person would have wanted, right? So we can solve that problem. You can create a will and a trust that creates no boundaries, no barriers to entry for that conversation to happen for your people when you pass or when you become incapacitated, which we'll talk about. And then here, I just want to make a really important point here. You don't need to have it all figured out. That's the point of you coming and seeing a financial advisor or a CPA or an attorney to talk about what you want to do. It's our job. Your job is to know what your values are, to be able to articulate your priorities to us. You let us do that grunt work. Let us do that kind of planning phase with you. Because so often, and this is kind of a normal thing, right? Like we don't set out on journeys not knowing where we're going usually. We want to kind of have a guide map. We want to know exactly where we're going to go before we start the journey. But in this case, I'm just going to tell you that is what keeps people out of our office, and that is what prevents people from putting these things in place, and then they pass or they become really ill. They end up having to sell the farm or do things that they would never have done if they had just come in years earlier. It's just how it works. So you don't have to have everything figured out. Matter of fact, I would suggest that most people don't have it figured out when they come into our office. Like, I know this is what I want to do, I just don't know how to do it. So if you're there, then you should take the next step, which is talk to a CPA, talk to an attorney, talk to your people, right? I know this is hard to tell y'all, but I've decided that I'm going to keep this farm come hell or high water, and it looks like you guys are not going to get that cash out if something happens to you. But you will get the opportunity to be on this land, right? You will get the opportunity to bring your children here, or your spouse, or your significant other. You will get the opportunity to come to this land anytime you want to and enjoy it. And we set those things up, right? So you don't have to have it figured out, and something is better than nothing, okay? If you die right now, and statistically, I won't make anybody raise hands, but statistically, half of you do not have anything in place. Statistics, right? So if we did a show of hands and most of you raised your hand, then we would all just get points for the day because we have more than 50% of you. But my point is, for the 50, there are half of you in this room who have something in place that's better than the other half of you who have nothing in place. And why is that, right? Like, because the law in the state of North Carolina is going to tell you what happens to your stuff. Simple as that. And I don't know about y'all, but I don't like it when the law tells me what I have to do. I was looking online today, this morning, for a client for a permit they're trying to pull in Orange County, and I didn't like what I was reading. I didn't like it. And so I thought I would share that with y'all today because I was like, this is exactly what I'm talking about. I don't like it when the law tells me what I can and can't do. So if you want to make sure that the state of North Carolina is not the one that tells your people who gets your stuff, we have a solution. Something's better than nothing. If you are employed, a lot of times your employer will have like a form will, better than nothing, right? The lawyer in the room is here to tell you, I would rather you have a will that I didn't create than not have one at all, okay? Call friends and family, ask them who they used. It's not as important that you have it just right. It's important that you have mostly right, right? As much as you know, right? I just don't know what I want to do with the land, but I know that I want any cash to go to X. Okay, great. You can start there. These things are all amendable, revocable, changeable. Nothing's set in stone. But if we do nothing, that is set in stone. We cannot change it. There's no petitioning and saying, look, here's the will that they made out, they just never signed. You'd be amazed how many people come to our office that we have to chase down to finish their trust. Like, hey, you paid us money, we have this thing, come back in and sign it. What's happened is they've told their people. This is what happens. They go, they tell their people, and now they're second guessing, or now something's crept in, or their health has changed, or things start to change even before they get something signed. And the real danger of that is nothing has been signed. In their mind, they're kind of halfway there, but according to the law, until we have notaries and witnesses and attorney in the room that watches you do that, we are not good, friends. So, something's better than nothing. So if you don't have anything, work towards something. We're going to talk a little bit about what we would recommend if we really did a comprehensive plan to meet, I'll tell you, every single person in this room's needs, okay? All right. Questions before we move kind of forward and talk about incapacity? Some statistics, the only ones on the slides, I promise. Your chance of incapacity, if you have reached the age of 65, is over 50%. Which means that at some point before you pass away, you will be unable to make decisions for yourself and for the businesses you run and for the farm that you work on, the land that you own. And if you reach the age of 80, nobody in this room is 80, so anybody who has a grandparent, that'd be nice.
How many years do I have?
Right. If you reach the age of 80, you are way more than likely, that's a legal term, way more than likely to be incapacitated at the time, but at some point to some degree before you pass away. And the older you get, the longer that incapacity stretch is, statistically. You know how this works, right? Like medicine gets better, they can keep us alive longer, and that's just kind of how it works. Women, bad news, you guys live longer, so your chance of incapacity is even greater than the gentleman sitting next to you. So just things to think about, okay? Things to think about. So incapacity, we talk a lot about I need a will because I'm gonna die. I don't need a trust because I've got a will, right? That's great. It really is. I am not knocking, I'm throwing no shade, as the kids say, at having just a will and no trust. What I am telling you is that that will does absolutely nothing until you're dead. You have to be dead for that stuff to happen, okay? So, a couple really important things. We're not going to get into LLCs quite yet, but I want to talk about it in the context of this because it's so important. And it's missing in most of the farms that we see. We have a really important ingredient that's missing. But the first thing is the power of attorney. You guys have heard this term, right? It's powerful, right? You have a power of attorney that basically says, if I'm incapacitated, the following people can do things on my behalf. Really important document. So that if you will become incapacitated, somebody can go to the bank, pay payroll if you've got people working on your farm, can go and pay just regular old bills, pay your mortgage, the note, make sure that the guy who pulls up the hay has access to the keypad. All the stuff that happens on farms, if you're incapacitated, you have the opportunity to have somebody speak for you when you cannot. At our office, we tend to make these what we call durable, meaning that they're actually active immediately. We don't wait for incapacity. That's called a springing power of attorney. Those are great too. The durable power of attorney is nice because, for example, I use this a lot. My sister was working overseas during COVID and was expecting to come back and have her lease on her apartment in Burlington and all that, and couldn't come back. So I, as her power of attorney that we executed before she left, was able to go and handle her business affairs, even though she was technically capable of doing these things. She just couldn't physically be there and go to the bank and go to the lease office and take care of business. So I was able to do that on her behalf. So powers of attorney in our office typically, unless we have a reason, again, remember? On your situation, but typically we make those durable because we just don't know under what circumstances you all of a sudden are incapacitated. So powers of attorney. The other one is an operating agreement. That is in the context of LLCs, which is coming up in a second. But why is that so important about incapacity? Well, that's so important when we talk about incapacity because if you have an operating agreement, it will say what happens in the event of your incapacity as it relates to your business. Okay? So if you have a business partner, maybe that doesn't matter to you. Maybe you're like, well, they'll just keep running the business. Well, that's great until business partner decides to change a lot of the business while you're, and people get scared when people are injured too. It's not like people are just waiting to kind of run to Vegas and spend all your money. It's legitimately a horrible situation. There's been a bad diagnosis. There's been a really horrific accident, and out of nowhere, the one who never handles the business, who never runs the payroll, who never, communicates with the folks working the farm, is doing all those things. And so I think we kind of just think in our minds it's never going to happen, but it happens. And so the operating agreement is in place to say what happens during your incapacity. One common thing that we do, just to give you an example, and we'll move on and I won't digress, is we put a timeline on how long a person needs to be incapacitated before the other business partner would take over in terms of like making big business decisions. We don't want to keep business from operating, but we certainly don't want to just willy-nilly give away a person's opportunity to continue making decisions for their business. So we might put something along the lines of 6 months, right? Someone has to be incapacitated for 6 months before they could sell the business, before they could add a new member, before they could do certain things. So we just create guardrails to protect your interest in your business. It's kind of a simple thing, but this is missing in so many situations that we see. Your farmers are so risk tolerant, otherwise you wouldn't be farmers, right? And you're resourceful as heck, so you are willing and able to form the LLC on your own. Secretary of State's office, pay your money, file the information, and you're formed, right? You pay your taxes every year, all good. Problem is, you don't know what you don't know in terms of the operating agreement, so they aren't there. It's important. It's a really important step for succession planning that we have this operating in place for your farm. And even if it's a holding company, a lot of times we'll just set up LLCs for land. Like the farm isn't actually like an operational commercial farm, it's just holding property. We'll set up an LLC specifically for that land. We have an operating agreement. Even when it's just like a single owner, we have an operating agreement. Let's say 10 years down the road, you want to go get a grant, right, to improve the property or to allow some study to be conducted on the property, and you want a little bit of money from it. First thing they're going to ask you for is, where's your operating agreement? And you're going to have one. It's just, it really makes the barrier to entry to utilize this land to its fullest and best as you see it. It just makes it much easier. Okay. I want to get away from incapacity because we're kind of going to circle back to it in a roundabout way. How are we as far as questions on incapacity? Good? Okay. So, moving along, talking about businesses. Can I get a show of hands? People who own an LLC in some capacity, related to the farm or not, it's relevant. Okay, a lot of you. Cool. This is going to be very relevant. So we talked about operating agreement. I'm going to not belabor that point. You need one, okay? If you have, and let me just make this really like clear cut. If you have an LLC, does not depend, no depends, okay? You need an operating agreement. Full stop. Okay. You also need an LLC. If you're a sole proprietor, that's great and that's awesome and there's absolutely nothing wrong with it. There is just a better option for you. Better is better. Most of the time, it's better. There may be a rare instance, but the reason is most of the time better for our farmers, which is y'all here today, landowners, farmers, is because we protect and shield from liability. Okay? If you live on the home or you've got 30, 40 acres, 100 acres or something, and that's the business where the business is operating, we do not want your home to be subject to a litigation because somebody was hunting on your property and was injured. Their fault. But it's still going to subject your personal life to the goings-on of your business. You have an employee who's injured really badly, working on a piece of equipment. If you don't have that LLC in place and you're not paying that employee through the LLC, they're coming for your personal stuff. And again, it always seems like I'm saying something like, oh, there's somebody like hiding in the bushes waiting to like do you wrong. But that's not what we're talking about. We are talking about the likelihood that you don't have workers' compensation insurance, okay? And that person is horrifically injured. They're at UNC for 3 weeks. Their medical bills are now in the very high 6 figures because of all the surgeries that they had. And they don't have the ability to make a payment. You have insurance on your property. They don't have a choice but to sue you for coverage for those medical bills. You're friends. You're related, right? But all of a sudden they're, 5, 6 figures in debt and have no ability to pay for it. They didn't have personal insurance, or the personal insurance that they had covered just like the slightest little bit. You're the one with the coverage because you own the land. They're coming for it. Not because they're mean people, but because they have, a life to live and hopefully recover from, if we're lucky. So I just share that because we want to create protection so that you personally, your property, your home, your stuff is not going to be subject to that litigation, right? We're going to have an LLC in place, and people always say, well, my CPA told me I didn't need one. I love when people say that because it's great. They're right, technically, okay? They are. From a tax perspective, oftentimes, there isn't actually additional filing if you have an LLC. Why would you do an LLC? You don't need an LLC. Technically, from a CPA perspective, that may be true. From a liability perspective, that's not true. From the lawyer's perspective, I am trying to shield my client personally from as much liability as I possibly can because we're in farming, okay? It is dangerous. There's literally warnings for that, okay? So we want to make sure that we're creating space between your personal life and your business life, your farm life. That's LLCs. While they're important, power of attorney we talked about, that's really important. It will speak to whether or not your person, your agent, is going to be able to help manage affairs, right? So that's why the power of attorney is really important for the business farms, for the business documents for farms, because if it's one thing to say in your operating agreement, you know, setting up kind of the rule, the playbook that we're going to play by. And it's another thing for somebody to be able to go to the bank, and maybe they're not the check writer of the organization, but you want that manager who typically milks the cows to be able to at least make payroll. They're going to need to be able to do a few things. You can set that up through your power of attorney. It's important. We just essentially check a box in North Carolina to say, yes, they can handle business affairs. And then lease agreements. So lease agreements are one of those things where people, whenever we talk about lease agreements, so we've done like a whole presentation on them at Carolina Farm Stewardship Association in the past, and it's real divisive. What did somebody say? Touchy. It's touchy, yes. Okay, why is it touchy? It's touchy because you don't want a lawyer coming in and telling you gotta do all this stuff. Like, that's why it's touchy. Like, just let me do my stuff, right? So I will say in our office, what we try and do with our lease agreements is we try to match what you're already doing. We don't want to come in and say, well, we're releasing you of liability for this, and we're releasing you of liability for that. Like, all of a sudden, nobody wants to sign this 20-page document, okay? I get it. On the other hand, what we see a lot of times is, for example, somebody passes away, and I'll just use hay, kind of came to mind earlier, I'll use it again. Somebody has cut hay on this 10 acres for the last 30 years. It's been a handshake agreement since the, however, math, 70s. I don't know, that ages me. That seems like 30 years ago to me. Okay, whatever. A long time ago, they had a handshake agreement and they decided to allow him to cut hay, right? And so that's just happened. All of a sudden, a person passes away, and the kids, who may or may not have a whole lot, that guy, he comes, remember, he drives the green truck and thing. He does the thing. Nobody really understands what's supposed to happen, right? There wasn't anything in place, so now all three kids are stuck owning this property. Nobody wants to farm it, and farmer who does haylage is like, I've been doing this for 30 years, now what? No one knows what. Neither party knows what. So if we have a lease agreement in place, as basic as it can be, the lease agreement will essentially survive the death of a person, if you want it to. Or you might say, upon the expiration of the lessor, it terminates. Or call this number and talk to my son. Or call this number and talk to my wife, right? It just depends on what you want. So lease agreements are really important for farm succession because all of a sudden, you have a couple different people with no idea what's supposed to go on because no one set up the guardrails, the playbook, if you will. And people think, oh, lease means dollars. Not necessarily. We do tons of leases where no money is exchanged. No money is exchanged. We have people living in other people's houses. We have people farming other people's land. We have horses. We do a ton of equine leases, believe it or not. So there's lots of leases that we can craft in the farm space where absolutely no money changes hands. I will be very clear. Liability changes hands, right? If you're a client coming in, we're going to shift as much liability as we possibly can under the law to the other party. because you are our client, and our goal and our ethical requirement is to protect your interests, right? But at the end of the day, if they get an attorney and you guys say, well, that's too much exposure, then we'll come to an agreement, right? We'll both bear the load together. It seems, this is one of those head spinning things, but if you've got people doing something on your property, you probably need a lease. You probably need a lease. And it's also a protection for you in the event of, I'll go back to the conversation we had a minute ago, liability. Summer camp. You got somebody coming over and just doing, you know, a demonstration for, I had a wood whittler situation not too long ago. That's dangerous. It's knives. And people who don't use knives hands, okay? From a lawyer's perspective, I really want some kind of waiver in place, right? Waivers are also great. I didn't put that up here because if you don't have people coming onto the property, it's not as important, but if you do, that would be another one up here. But lease agreements, I just want to kind of go back and mention that it's really not because you feel like somebody's going to shortchange you or somebody's going to treat your property badly. It is because we don't have control of so many other things around us. That lease gives us kind of a security on both sides that when there is a flood that we have not seen in 100 years, when there is a virus that goes around that keeps people home for 2 years, when there is a catastrophic death in the family, we know how we're going to handle this little piece right here. We got covered. Okay, so that's why leases are important. Questions about that before we move on? Yeah.
So, what if someone is asking to hunt on your property?
Yes.
I know that the North Carolina Wildlife has a template for
Yes.
a lease agreement. Is that something you would recommend?
Absolutely. If you have anything, I mean, farming in and of itself is dangerous. The law even says so. I didn't make it up. And y'all know this, right? And especially when you have people that aren't necessarily farmers, right? Who get it and they see a cow. Oh my God, let me walk up to this cow. And they have no idea what they're walking up to. They just don't know. I grew up on a farm, so when I see it happening, I was like, oh my God. But it is truly a thing you have to think about. So to your point, yes, I will say Agritourism Board has a really great resource. In North Carolina, Farm Link has a great resource. It sounds to me like there is a hunting and fishing potential lease situation available. Something's better than nothing, like I said. Have some, now here's the thing, read it. Okay, read it and make sure, even if you call our office and we look through it for you and you're like, this is one paragraph, it doesn't make sense. Make sure you understand what you're using before you have people sign it. And the reason I say that is because you would be so surprised how often, and ChatGPT is here for all of us, okay? AI is real. What happens, people they ChatGPT, draft me a lease for a hunting and fishing permission. And it spits out this great looking thing. It does. But what happens is it's pulling from these crazy places, and it might be essentially not giving away any, not requiring any kind of liability release. Just like, hey, you have permission to come here, right? Or it might be giving it to the other party. Making sure you understand the parties is so important. We see that all the time. It's very common when we have people, yeah.
Is it the same as, is the lease agreement the same thing that protects you from liability, or is that possibly something separate to protect your liability?
Great question. The question was, is the waiver of liability going to be in the lease, or is it a separate document? And the answer is,
Maybe.
yes. Look, we are going to always, if you come to our office, we're going to add language about releasing liability.
Okay.
Yeah. One of the common things we ask is, are you a bona fide farm? Right? Do you have animals on your property? But there's language. Equine is a whole nother separate category, as a matter of fact. But if there's going to be those types of activities on the farm, we will include specific language. And frankly, there's a whole nother, we could have a whole nother conversation about this. There's required posting. You've probably seen this, but there's actually required, this is a true story. I love lawyers, I do. I love the law so much, I do. They just edited, essentially, the rule for agritourism and equine and farming warnings, signs. Used to be an inch. You had to have an inch tall language in black and white. Now, ladies and gentlemen, I'm excited to tell you, it only has to be 3/4 of an inch. Okay? I'm not joking. You can't make this stuff up. Okay. But that's true. So we would include that verbatim language in the contracts that we had, whether or not that license, that agreement that you were speaking of would have that specific language. Couldn't say. If it's specific to North Carolina, it probably does. Again, something's better than nothing. Just read them. It is worth a couple $100s to have an attorney look at it and say, yep, looks good, than it is to sign something away that is like, could be $1 million or more. We're talking about insurance policies maxed out with a horrific accident like hunting. Okay, those are just things you don't want to chance. Again, I know that this room is an inherently risky group, risk-taking group, because you wouldn't be farming land if you were risk not, I don't know, I'm backing out of that one. Okay, you guys are risk tolerant, that's what I was trying to say, so, yeah.
What are the protections for a landowner whose neighboring landowner shoots on their property, like guns of all sorts?
What are your protections?
What should one have in place, or what
So-
to protect ourselves?
Yeah, so the question was related to a landowner, adjacent landowner shooting firearms. There are specific rules and regulations to firearms. In order to have a lease or an agreement or a waiver, both parties have to come together. So unless your neighbor was interested in doing something of that sort, there would be no requirement that they do that. Yeah.
S corporation versus LLC.
S corporation versus LLC, great question. There are instances where an S corp is a great opportunity, a great situation for our farmers. Typically, we are not recommending S corps. The regulations and the rules that you have to follow for an S corp is a lot more stringent. That's why we created LLCs, because it makes it so much easier for a small business owner to be able to utilize. You can be taxed, okay, so to be clear, you can be an LLC and select a different tax status. Matter of fact, you can select an LLC and be a pass-through entity if you're a single owner or if you're married. So there's tax treatment and then there's actual formation. In our view, most of the time, again, most of the time, our farmers get along very well with an LLC. There was another question, yeah.
You, on your first slide, you talked about business structures,
Yeah.
and the three that I'm familiar with are LLC, S corps, sole props, and partnerships.
Yes.
Are you going to discuss the differences for each of those structures?
We are not, the question was, are we gonna get into different business structures today? We are not gonna do that today. We'll talk a little bit after, but I'm happy to stick around. I kind of maybe mentioned, I don't know if I did, but we can certainly, talk offline about that. That's a whole nother topic. Maybe it looks like, I don't know, spring, maybe the spring one. But we're not today. We're not gonna get into that today because LLC, for the most part, is a really good fit for most of our farmers. Okay, we're pretty close. All right, this is the slide. If you're wanting to screenshot it, it's the one you might screenshot. If you come to our office and you're a farm landowner, whether it's in a commercial operation or not, and you care about keeping land in your family, because this is why we're here today, this nice little slice of cake is what we're going to do, for the most part. Briefly, I'm going to run through these. I've got one little extra slide and we'll go to questions.
May I ask a quick question before you begin?
Where is this question coming from? Oh, I see, sorry.
Yeah. You're talking as though people have one tract of land, and many people over years may have accumulated several tracts of land.
Yeah.
When you set up an LLC, it does not specify that you have to put a identification number of the tract of land.
That's correct.
So how is somebody protected with an LLC for tract of land A when the LLC doesn't cover B?
Great question. So the question was related to land ownership in multiple tracts versus and how that protection extends if you own if one piece of tract is owned by an LLC and there's another piece of property that may not be part of that LLC. Great question. So actually, the entirety of this conversation has been, and if I didn't make it clear, definitely, sorry I didn't do that. This totally applies to multiple tracts of land. Matter of fact, in the course of some of our planning, we may at times recommend that we parcel off pieces of land, particularly if you live on the home. Again, it depends, but there are times where we will actually recommend partitioning to create additional protections. But to answer your question directly, it depends on how large the land is, what is on the land and what's being done to the land. But generally speaking, you can own multiple pieces of property. You can own one in Orange County and one in Chatham, or one in Orange and one in Watauga if you wanted to. And it can be still owned by the same LLC. What we want to make sure we're doing is that we're associating the risk there, because we don't want a property that, let's say, is a rental unit where somebody's like, there's a higher risk of injury, of issues that go on when somebody lives on a piece of property versus just vacant land in Watauga County. We want to make sure that we're not putting too many pieces of property in one singular property LLC, because if one of them is litigated, then the others are potentially at stake. So there are instances, depending on the property, where we actually have multiple LLCs owning different properties. Make sense?
Yes.
So if you have one that's really risky or commercially in production, the likelihood of us recommending that you actually put anything else in that LLC as far as owning property is pretty slim. If it's doing the exact same thing, maybe, but even then, you can lease to yourself, right? You can lease the LLC, farming LLC, the commercial property, can lease from you or from your property holdings LLC. And that's a really smart thing to do, right? It depends on how the property's owned, if there's encumbrances on it, are there easements associated with it. There's lots of things that we have to make sure we flesh out before we start putting stuff in, deeding things to LLCs. But as a generalization, owning property outside of your own personal name is a really great option. So to my point, moving on, a trust is a really, really great tool for protecting property, not just land, but the actual interest, assets of the farm, and for keeping that in production if something happens to you. And you've got a couple kids, one lives in Florida and one lives in Raleigh and is in school and have zero interest in farming. The next thing we talked about LLCs, the LLC operating agreement we talked about, power of attorney. Healthcare power of attorney is also a power of attorney just related to your care, your health care. And the HIPAA is a document we put together that just goes with it. Advance directive is also called a living will. You've heard that. So we've kind of come to this conclusion that you are not going to have life as you knew it, right? An advance directive is going to talk to your healthcare providers about how you want to die. Do you want to have artificial nutrition, hydration, that kind of thing? It's just something you need. You just don't want to leave that to chance. You want to let families fight over something. It is your care in the last days. Unfortunately, that is something that we see. Bill of assignment, those are just, if we have a trust, we are going to assign over your interest in your business, in your assets, the tractors, the cattle, to a trust if we create one of those. And then the leases, like I said, maybe. I want to get to this last slide because I want to not take too much time, but I want to be really clear about this trust situation. Because people hear all the time about trust. It's a big old TikTok thing these days. I've had so many people be like, I heard on TikTok I can do this. Shield the taxes from, no you can't. I'm glad you learned it from TikTok. But one interesting thing I always like to make very clear, a will is not an or a trust, okay? A will is an and a trust. Everybody gets a will. Like Oprah Winfrey. You get one, no matter what, okay? If you're doing a succession plan, you are going to have a will. The difference is, if you have a trust, if we decide that a trust plan is a good plan for you, your will is going to do what we call legally, it's super technical, follow me, pour over, it's called a pour over will, into your trust. Okay? So you're still going to have a will, but rather than say, divide my stuff between X, Y, and Z, we're going to say, give all my stuff to my trust. Okay? So the idea is, and again, this could be a whole nother conversation, the idea is that we reduce the amount of things that you own upon death to reduce the amount of essentially of work that your executor has to do and the taxes that you pay upon death, and allow this trust to function and tell your trustees, we name a trustee, what to do in the event of your incapacity or death. That's the other really big thing about a trust, is we have two scenarios with a trust. One of them is incapacity, one of them is death. In a will, we just have the death, right? So with a trust, and I use this picture on purpose, I usually describe it as like a treasure chest, right, with a lock on it. And the trust and the lock is yours. That box you get to carry around for your lifetime. You get to put stuff in, take stuff out. You're the only one with the key. And then when you pass away, your trust tells everybody, well, privately, but tells the powers that be who gets the key. Okay? And then the trustee who has the key is the one who's going to divvy the things out according to your wishes. So during your lifetime, you have the box. You have the present to wrap and unwrap and rewrap, all the things. Put in it whatever you want to put in it, and then upon your passing or upon your incapacity, somebody else gets to take over. You have already put the box together. You have chosen the wrapping paper, the ribbon, all the other little tchotchkes people put on presents these days, and they're going to work according to your wishes. Does that make sense? What I'm saying about the trust, kind of oversimplification. Most of the time when somebody comes in and owns a farm and says, I want to keep land in the family, it involves this box, for sure. Unless you have a very, 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 just like, I do not want to trust. That's really the only reason that we don't do them. They're just so helpful. We can create a land trust. We can create a box within a box if we want to that holds land. Maybe it doesn't hold land until you pass away. And then we give the land to the trust, the land trust. And it's managed by who you say and used for the purposes that you say for however long you say. It's one way. We have recently done a nonprofit formation for somebody who wanted to keep does not have children, does not have anybody they want to leave it to, has a wildly successful commercial enterprise on their farm, is very interested in that land being used for that specific purpose forever and ever, right? The law does not like forever and ever, okay? Does not utilize trust mechanisms as a forever and ever.
There's no perpetuity.
Perpetuity, yes, that's like the word. Yes, there is a rule against perpetuity, which I'm going to be honest with y'all, I don't think I got it in me today to talk about that one. But yes, we have to put parameters on the trust. We still have to have parameters on a nonprofit. I just mention it because he does have a really great community of people who are interested in him continuing those efforts. So a nonprofit made a lot of sense. The nonprofit will, upon his passing, we've already got the board established, the nonprofit exists now, but it won't own property, it won't operate to be a school of sorts in agriculture until his passing. But it was a really cool tool that we used. It goes through the trust though, right? So he has a trust, and inside that trust box is this little nonprofit. And then that little nonprofit is what is going to allow his property to continue operating as a farm. So it's a unique scenario, not the best one for everybody by any means, but I can almost guarantee you if you own land and you want to keep it in farming, a trust is going to be among the mechanisms that we request you put in place. Obviously your choice, yeah.
I know this is probably asking something that can be very complicated. How do we think about incorporating things like conservation easements and that sort of thing into this land trust box?
Yes. Great question. Like, oh my gosh, ding, ding, ding. If I had another 20 minutes, I would have put this slide on there. The question was about easements, conservation easements, agricultural easements. They are wonderful tools for very specific purposes, okay? We see wildly successful scenarios where people have put things in conservation or put things in agricultural easements, and it's creating the scenario where we essentially I don't want to say devalue the land, because in my mind, that actually makes it valuable, but, you know, I digress. We're essentially making it so that somebody would essentially later on buy that property with that easement attached, meaning we can only use it for a certain purpose. That's a really great option for a lot of people, and we don't have any problems with those. What we see on the streets, right, is that people have done this years ago, and then kids are now grown and have family and are interested in coming back, and they want to start a flower farm, or they want to build on the property, or they want to Airbnb or tiny house world or whatever it is, and they have real problems with that. All of a sudden, kids can't use the property the way they want to use it because we've put something in place that limited that. And so I don't think they're a bad idea. I just think that they're an important in consideration, and definitely not first stop on farm succession, right? I would say that is not your first stop on farm succession. It may absolutely be a solution, for sure. But we just want to make sure that we think through, again, in that slide in the beginning, we talked about values. We want to make sure that that easement that you are signing up for is consistent with what you're telling us, with what your values are. And if you are interested and frankly approached by, I mean, they're very popular, great organizations out there that are doing wonderful things, and I am absolutely eternally grateful for them. I just think sometimes in the kind of conversation we forget, oh, there was that LLC on it. Oh, there was our daughter who did express interest, or our grandson, or our friend down the street who really wanted X, Y, or Z, that would also accomplish the same purpose, and even in a lot of ways more than what an easement would do. So they're great. They're great tools. That's kind of like I would say in summary, wonderful tool. Just make sure they're the right tool. Yeah. Yeah.
If you already have a trust that doesn't include what's really needed for farm succession, would you dump that trust, create a new one, amend it, or have two separate?
Great question. The question was, I don't know if can y'all hear each other? Okay. About if the trust isn't specific to farming, and again, it's kind of one of those little.
It depends.
Yeah. Depends on the trust. Depends how old the trust is would make a difference. There's a lot of the law changes. Believe it or not, it's really slow, but it does change. We've had some things recently in the legal space related to trust, Secure Act 2.0, among some other things, that would kind of probably be nice language to add, to amend if you had your trust done several years ago. But in certain instances, if it's really just a piece of property, you could potentially just do an amendment. Like, and let's say you acquire a property afterward, the way that is designed to work is that we contemplate that when you come to the office. We say, okay, do you think you'll have more? What if you have, you might inherit from a father or another family member? Okay, cool. Let's make sure that we create language that's going to be broad enough to cover that. And then what you can do is it's really about deed work at that point, right? Like we're deeding property to the trust. Like my personal home is in my trust. It doesn't have to be. There's another lawyer would say that's not necessary. It's not necessary. It's true. But I like it because I like the thought that if something were to happen to me or my husband, and my sister, who knows I have a house but doesn't really know anything else, isn't going to have to go through a lot of the legwork to make sure that she can hold that trust for our daughter, for example, or not, because that would be a horrific situation, right? It would be a horrible scenario to contemplate that I and my husband are not there to say. And so I like the fact that my home is already in my trust so that I don't have to even deal with that. She doesn't have to make that decision, right? We don't have to go through probate and let the court check off what we're going to do. So that's just kind of my own personal scenario. But anyway, so it depends on the scenario, what you're trying to do to, Questions, other questions? Okay, cool. Well, sorry.
If you have a soil problem, which you got because you bought 10 acres, at some point you decided to start farming,
Okay.
buy a cow, and you make out a Schedule F, and now you're a farm.
Okay.
You and your wife or partner own the land.
Okay.
and the farm, I don't know, I guess owns the land, or it's a business you run on your land. And then you come to this seminar and you find out about LLCs,
Yeah.
trusts, and so on and so forth. If one did go ahead and create an LLC, who would own the land? Do you have to transfer
Great
the
question.
land
Yeah,
to the LLC? Do you
Yes.
continue to run the business
right.
with your own land? Do you lease the, that.
Yeah, it depends, again. If there are encumbrances on the land, that might, meaning a mortgage, if you have a mortgage on the property, there may be certain instances where we don't actually deed your land into an LLC. We don't typically recommend that you have if you own land and you live on the land, very rarely are we recommending that we have the LLC own that, because you get where I'm going with that, right? Like your house is still subject to any of the problems. That's just a conundrum that, quite frankly, a lot of our farms do face, and we have other ways around it. One of them being leasing, parceling off a portion of the property where the commercial operation is taking place, and that being leased by the homeowner or the business owner. But yeah, you absolutely would essentially be deeding, assuming we don't have your house on the property, we would in that scenario be deeding the property from you personally to your LLC. When we create the operating agreement, there's a back page, really easy, about what you're contributing initially to your business, and a lot of times it's the land. We just put the name of the land on there, and 100% owner gave this land to the LLC. We filed the deed paperwork, and now the deed reflects that you gave your property at, OrangeCountyRoad.com, whatever it is, to the LLC, and then the LLC owns it. There are ways we get around it, even if you have a mortgage, but that's a case by case. Yeah.
Would it be better to not have the land in the LLC, so if the LLC goes belly up, the land don't go with it?
That's a great question, and it depends on the scenario, but yes, a lot of times when we have people that own a pretty chunky property, a lot of land, and you have a business operation, a farming operation, those are a lot of times two separate LLCs. For that exact reason. Somebody gets hurt in a hunting accident on the land, you don't want to lose your dairy farm, right? Vice versa, somebody gets really horrifically injured on the dairy farm, or you make a lot of people sick because there was some bacteria, you don't want to lose your 100 acres. It depends on the risk, right? The type of risk that we're dealing with. Yeah.
You keep using the term farm. What actually legally makes a farm? Is it just having a farm number?
I mean, technically there are, obviously the legal, my husband is the land use guy, okay? I'm more of the planner. He's more of the, let's push the boundaries, no pun. Yeah, so there are like actual legal definitions of farms, but you all can decide that you have a farm, right? Like you have a farm. You may not get the tax benefits, you may not have some of the protections liability-wise if it's not an actual bona fide farm, but the term farm is not a legal term of art in the sense of this conversation, right? In terms of succession planning, doesn't matter. We could take away the word farm, and I'm not gonna tell you I did this for the presentation or anything, and put dental office. Like it's the same, it's exactly the same, yeah. There are also legally some other things related to professional medical practices, right, that don't apply here. Same with farming. There are some tax benefits, there are some, whether it's present use value or bona fide farm status, that do make a difference. And we certainly ask those questions in the context of our planning with you. But sometimes, for example, we will lose sight of the forest for the trees kind of thing. Yeah, because we're like, I don't want to lose that PUV status. I don't want to lose all of that. But we forget that if we don't come to the office and do something, like let's risk that, okay? Over having to have your kids sell this property because we didn't set up a trust plan or we didn't set up a will. Because if you die without a will, whoever your heirs are, and again, you don't get to decide that. The state tells you what your heirs are. Those people will jointly own that property. So they've gone into business with each other, right? Now they're farming together. And I don't know about y'all, but I don't know a lot of families where everybody agrees exactly on the same page on what needs to happen to the property or to the farm. So, yeah.
Just PUV status. So I'm the PUV compliance review appraiser down off of Orange County.
Yes, stand up, take a bow.
I just want to say thank you, but yes, so just communication, losing the PUV status, just communication with me to get everything updated, that's all I ask.
Preach. Yeah, and that's another thing too. When you come to the office, that's what we're asking. Like, let's not move any deeds, let's not transfer any property to anybody until we have this conversation and understand what your values are and what you're trying to do. I can't tell you how many times we've had situations where people come to the office and it's after the fact. Well, I went ahead and gave it to my son because he wanted to build a house, and I'm like, okay, that's good. It's good. I'm not mad. I'm not upset. It's your life. And so it just, we utilize tools to our advantage when we have the ability, but when the ship has sailed, there's not a lot of stuff that we can do to fix it, at our office anyway. So other things as far as transferring property within your lifetime, that is generally not a great idea. It's an idea. It's not a great idea. If you're looking to protect land, this is not of a huge consequence, but in the grand scheme of things that happen in life, particularly if you don't come in and get a trust plan done, there is a step up in tax basis situation to consider. So that if you gift property to somebody during your lifetime, to an heir or to somebody else who wants to farm, there's going to be, the tax basis is reassessed. But if somebody inherits land, now that can change. This is always up for debate when we have a new cycle of political charges. But for now, you inherit also the tax basis. So you will lose that if you go ahead and decide that it's a great idea to go ahead and split it up 3 ways before you pass. Again, we're not going to lose sight of the forest because sometimes that is the best idea. We would rather give up that opportunity and risk that one of my kids is going to have to sell it in a divorce or because they got to send a kid to school and some of the property stay with other kids. But it's generally not what we're going to recommend. We're not going to recommend that for various reasons, that being one of them. And protection of that PUV status as well. Yeah. Okay. Yeah.
So what do you do when you have land and, you know, let's say you have 100 acres and it's in forest and your kids don't want it and you just want it always to remain as forested land?
Yeah.
Do you give that to like a land trust or?
Yeah.
And is that truly going to remain that way forever and ever, or is there like, you know, stipulation that after 100 years it can be?
Yeah, it's not really a specific number of years, but there are opportunities for you to essentially, you can gift your property to another larger land trust. I obviously wouldn't, if you came to our office, we wouldn't be able to say, yeah, sure, that thing will be around 100 years. We just don't know. We don't know. What we do know is that we can articulate and identify people in your life who would be good trustees and who would be willing to essentially name successor trustees to continue that land being what you say it should be, which is, like you said, undeveloped forestry, for example. I don't want us to go over too far. I'm gonna just, so what I was gonna say is I am happy to stand up here and continue answering questions, happy to kind of release everybody into their own farms and the day. Also happy to just stick around and answer questions individually if you guys have them. But would like to just say thank you. It really means a lot to me that every single person in this room is here because it means that you at least have an interest in protecting farmland to some degree, and that is so important. It's so important. That's a lot of land in here. We did the math, right? Mm-hmm. So thanks a lot.
Thank you.